Welcome to your long-range plan. This is the first in a series of shows that my co-host, Paul Tierney, friend and colleague, will be hosting and producing for hopefully the next year or two or longer, because the subject matter of this show is of vital importance to each and every one of you out there. And I've mentioned Paul, I've introduced him, but I'd like him to say a few words for himself. Paul?
Good day, everybody. My name is Paul Tierney. I'm an elder law attorney. I practice up in Quincy, Massachusetts, and also down the Cape. And we're going to be hosting this program about twice a month and talking about various elder law and estate planning issues that are important to you and that we feel that everybody should know about. We're going to pick a different topic every show and go into it in some detail. We'll also be looking for questions from the audience or people out there who may want to know certain issues that are important to them, regarding that particular show that we're going to be talking about. So please feel free to call us or to call in with questions that are important to you, and we'll try to go into them as we have the show on that particular subject matter. But like I said, this should be fun. This is to be educational, and we hope that you get a lot out of it.
Great. Paul, I'm going to take your lead on the educational component. Oftentimes, as practicing attorneys involved with estate planning, everything from simple wills to complex trusts, we are asked, do I really need all of that? And I know this is an overview show where we'll just touch on some of these subjects, but how do you typically, when you're encountered with that question, how do you typically respond initially?
Well, I try to find out what's important to them, and I also like to send out a personal information form on the particular client for the client to fill out and bring in to me prior to our consultation. I think that's very, very helpful, because then with that information I can ask some specific questions and try to find out what the client is trying to accomplish. I don't try to sell them on any particular type of estate plan, because everybody's needs and wants are completely different. So again, my job is to find out what's bothering that client, what they're trying to accomplish, what they're fearful of. And again, my job is to educate them, to give them potential solutions, and to listen to them and to find out, what's important to them once I give them several choices as to how to accomplish what their goals are.
We've been really successful with that model that you've just articulated. You and I have spoken so often about the need to be a good listener when someone comes in, whether it's an elder, him or herself, or an elder with their family members. We try to ascertain their specific needs before we draft or craft any kind of a document, so that when we do take all of the information, and I don't want to speak for you, but I believe that's why we've worked so well together. We take the information that we've learned from the individuals, and we create some options that they are free to choose from based on their specific needs.
Yeah, and again, also we never lose sight of the fact that we're trying to find out what's important to them. That's one of the first questions that I ask, because if they're trying to, say, protect their assets, then that's going to point in a certain direction. If they have a special needs child, or if they have a son or a daughter-in-law that they don't particularly trust, well, then that's going to give me some ideas as to how to resolve that problem for them. So first and foremost, I feel our job as elder law attorneys is to find out what's important to the client. What are their goals? What are they trying to accomplish? Then it can go from there. And of course, having the information about their personal situation doesn't have to get down to the nitty-gritty detail, but just a pretty good overview as to who owns what, how things are held, the approximate value of different things, different assets that they may have. Then that will give us a good jumping off ground to come up with some type of a solution for their particular needs.
So far, we've touched on a number of issues which have defined the need for paying attention to your long-range plan. Those words are pretty important to all of us, your long-range plan, because they encompass elder care, the appropriate care based on an individual's needs, and legacy planning for multi-generations thereafter. That would lead me to ask you this question. Is it a simple will or a trust?
It, again, depends on...
In terms of the educational component here, right?
Correct. And I think that's what we're going to be touching on, that's what we're going to get into in future shows. We're going to pick, one of these topics and go into it in a lot more detail. And there's lots of different topics and issues in elder law planning that are important. One would be, do I need a will or a trust? What is a trust? How does a trust work? Again, we can get into that in future programs. There's other estate planning documents that are very, very important and should be part of everybody's plan, such as a power of attorney or a healthcare proxy or a living will. Those are, again, some important components of an estate plan that we're going to be touching on and talking about in future programs. Also, Medicaid planning. How do I address my potential long-term care needs? What if I go to a nursing home? What if I want to be cared for at home? How do I make sure that that happens? So again, these are some of the different issues that we're going to be, fully exploring in detail in future programs.
So would you say that going forward, and this is our first show, Paul and I are going to be touching on a number of issues, but please realize that as we're speaking, we're crafting and pulling together ideas for various subject matter going forward, that the first show could be something like the essential documents,
right.
A simple estate plan, the will, the construction of the will, who the fiduciaries are. First of all, the individual we're crafting a will for is is the testator or testatrix.
If it's a female,
If
sure.
it's a female, on the latter point, we have to stress the importance of choosing a fiduciary, the executor or the executrix again, and the need for an alternate executor if the first choice as an executor ceases or fails to fulfill that role.
And I think along with the same lines, what if you didn't have your own, basic estate plan like that? What would happen if you died or became disabled? And again, we're going to touch on that and go into that in some detail in future programs. But that relates to the probate process in Massachusetts. Massachusetts, as well as most states out there, have their own rules as to how they would deal with issues like that, whether it's the simple issue of administering somebody's will that they already have in place. Again, there's a probate process that deals with that, as well as a probate process for dealing with a situation where somebody doesn't have any will in place. Then who's going to be in charge? Who's going to get their assets? And again, you may not like the answer to that, but again, we're going to touch on that and go into that in more detail in future shows.
So we're essentially talking, as you and I often do, about planning, preserving, protecting assets, creating a situation for a family, a loved one and family, so that there's an orderly transition when somebody passes away in terms of what that testator or testatrix wanted to have happen to his or her assets, in terms of whether something would be left to a surviving son, daughter, ultimately grandchildren. We'll talk a little bit about that orderly disposition as it relates to funds set aside for educational purposes, I would hope. Everything to what happens with the house, what happens to someone's home, that an
Yeah,
elder's living.
and also how assets are held.
Right.
I mean, that's very, very important too, because you can have the best will in the world, you know, I mean, maybe the best trust in the world, but they're not necessarily going to work unless your assets are coordinated to interact with those documents. In other words, sometimes assets can be jointly held. Well, legally, if somebody becomes, passes away, then the joint account holder is the automatic owner of that asset. Doesn't matter what the will says, doesn't matter what the trust says. So that's an important distinction, because I run across it many times that people try to do their own little estate plan, maybe without having an attorney involved. So they set things up jointly with their 4 kids, so they have 4 separate bank accounts. But over time, mom or dad needs to dip into those just for normal living purposes. Well, then maybe not going to come out equally when that person passes away, because bank account number 1 for number 1 son may be less than the other 3 accounts that, again, you wanted to go equally. So again, we're going to be talking about how, if you're putting an estate plan together, some of the things to watch out for, some of the pitfalls of having property that's, say, held jointly or passing by beneficiary designation that could thwart your existing estate plan. So it's important that all of that be taken into consideration. And another thing that, many times, as attorneys, our job is to, put the legal documents together, to do the legal work. One of the things that we can't do is really fund your trust or fund your estate plan with your individual assets. I can't go down to your bank account and say, hey, let's retitle this bank account into your trust. That's something that you have to do individually. Again, we can give you guidance as to how that's done, but you yourself have to go and do that, again, once your estate plan is set up. So I think it's very, very important that people realize that that's another aspect of this estate planning, is to make sure that your assets are coordinated with your estate plan so that your estate plan can come to fruition when and if the time comes.
2 good points. I've personally just encountered the joint ownership scenario that you've just outlined with a client family of mine. And unbeknownst to some of the siblings in this particular family that I've been working with, the decedent set up a bank account with 1 sibling. And when my client passed away, all of the funds in that bank account that were jointly held vested, right title and interest vested in the survivor. Much to the dismay, and it shouldn't be taken lightly, these are very important issues that you need to be cognizant of, as Paul just said, much to the dismay of some of the other siblings, family members, because a significant amount of money held in a couple of different banks became the property of the joint account holder.
And that probably wasn't what the elder wanted to accomplish.
And I was going to just get to that point, because if I'm reading you correctly, maybe it was an account set up for convenience, perhaps, and if you could elaborate on that.
Yeah, we run into that a lot. Again, doing probates, trying to administer people's estates after they pass away, we find out that they did have an account set up with, say, one of the kids. And usually it's with the purpose of, if, again, that person died or became disabled, they want one of the sons or daughters to have immediate access to an account so they can pay bills. I mean, that's usually the big concern. They want to make sure that if they die, that their funeral is paid for, if they haven't prepaid it beforehand. And again, that's another topic for another show. But many times people will set up their accounts with that purpose in mind, that I want, number 1 son or number 1 daughter to be able to immediately pay different bills if I'm not there to do that myself. So again, that's something that we try to discover, it's something that we try to anticipate, and if that is the preferred way that the elder or person wants to handle their, maybe their checking account, or to deal with last-minute bills or funeral arrangements, then we can put a provision in somebody's will that says, hey, look, we want everything to say go equally to the children, and to bring to the intention that, yeah, we do have a joint account set up with so-and-so, but that's just for convenient purposes. The intention is that whatever is left over be divided up equally and distributed to the, say, children. And so that's one way to do it. So again, that's all part of our job, to find out what's important to the client, how are they set up, and to coordinate their existing assets with their estate plan to make sure that it goes the way that they want it to go.
And you brought up another point, and that was the trust. We can create documents that will allow an individual to leave certain properties to certain individuals by way of a will, or we could, based on what we hear from the client, create a trust. But we cannot fund that trust. We can create the appropriate document, the trust. We have to counsel our client that you must fund the trust, or it's essentially a blind trust, and you defeat the purpose of creating a document that's going to spell out the terms or the directive that you want. You have 4 siblings or 4 children, for example, and you want to distribute your assets, or have your assets distributed 1/4 each to those children. Well, if you haven't funded the trust, that's not going to happen immediately. Unless, however, we create a pour-over will situation, which will work nicely with the trust.
Yes, and that's typically how a trust plan is put together, with a will, with what they call a pour-over provision. That would be the catch-all to fund the trust with individual assets held at death. It's much more efficient to fund that trust during lifetime if you're going to put the trust together. But again, as attorneys, we can fund that or put together a deed. That's a legal process. But as far as funding, mutual fund accounts or brokerage accounts or cash accounts, that's something that has to be done by the client. We can, suggest that maybe a beneficiary designation, a new one, be obtained from a life insurance company if we want the proceeds to go into the trust on behalf of the client. Again, it's something the client has to sign off on. So again, we can kind of help in that situation, but it's up to the client to bring that to fruition, to make sure that it happens.
And now we're navigating some pretty complex waters in terms of implicating financial planning and retitling assets in the trust name, and all of which we'll talk about in greater detail as we go along in this program, or during the program in subsequent shows.
But yes, and I think that it's important to know that, again, we're legal people. That's our expertise. But we like to think that we're part of a team. That's
right.
why I encourage with clients that we get to know their CPAs, that we get to know their financial planners, their life insurance people, because my feeling is we should all work together. I want the other professionals to know how the estate plan is set up, because we need some input from them. A lot of times they can help get some of these forms, change of beneficiary forms or change of ownership forms, to help facilitate the funding of, say, a trust or the funding of an estate plan, so that it goes the way that we and the clients want it to go. So I think it's very, very important that we establish a team approach to the estate planning process.
This is our first show. It is entitled Your Long Range Plan. We've touched on a couple of components in some depth, the will and the trust. Earlier, when we first began the show, you mentioned some other documents that you and I create frequently. Without getting into too much of the detail of a durable power of attorney and healthcare proxy, what would you say the most significant part of a durable power of attorney is? Or let's define it for the viewer.
Well, that's a document where an individual is appointing an agent for them to act on their behalf for financial and legal purposes during their lifetime. A power of attorney is a document that ceases at death. That's when the will would come into play. That's when the trust would continue, but the power of attorney would cease. And again, we'll have a separate show that goes into all the details of operating the power of attorney and what clauses and powers should be in that. But it is a very, very important document, and it should be part of everybody's estate plan.
Because the attorney, in fact, the individual or individuals acting as an individual or jointly, essentially step into the shoes of the principal.
Correct.
For example, I'm the principal of my power of attorney. I name you my attorney. In fact, you're able to, once that's fully executed, notarized, and so forth, you're able to go out and do all those things that I would normally do for myself. But because of some reason...
Depending on the language in the power of attorney. Right. In most situations, we want that to be very broad, because the agents that you're appointing to act on your behalf should be somebody that you fully trust. It does not have to be an attorney. The name of the person, agent, we sometimes use interchangeably as attorney in fact, but that doesn't have to be somebody who's attended law school and passed the bar exam. Most situations, if we're dealing with family, we're appointing spouses as agents for one another, if not their children as agents for one another, for the mother and father. So, yeah, that is again a very important document. It takes effect immediately. Okay, you don't have to be incapacitated for this type of a document to be valid and enforceable. That can take effect immediately. Usually you keep it off to the side and you just make sure that the people involved with your life, your family, that they know that this is in place and it's been executed. Because then if something happens, if somebody becomes incapacitated, that's when the agent should go get that original durable power of attorney, and then they can go down to the bank and get themselves added to make sure that they can pay bills and do some of the things that are necessary to carry out the wishes and obligations of the disabled person if it gets to that point. So that's a very, very important document, and again, we'll probably devote a whole show to that in the future.
To the various powers, we'll call them, within the document.
Yeah, the powers that you should have. Again, everybody's situation is different. Sometimes I've done them where we just had small specific powers, just trying to anticipate.
A limited power of attorney.
A limited power of attorney if something happened. Again, but in most situations we want that power of attorney to be very, very broad. But for a lot of your third-party institutions like banks, insurance companies, and IRA trustees, they need the powers to be specific in the document. So you have to really spell it out. And that's why it should be very, very broad to anticipate having to go in that direction and to not have your agent be handcuffed if you didn't have enough powers in there. So again, that's we can spend a whole half-an-hour show on powers of attorney, which we will do. I think it's very, very important. But to come full circle, I think that should be part of what we call a base will estate plan, if you will. You know?
And last but not least, we have a few minutes left in this very first show of ours, and let's not leave the healthcare, the Massachusetts healthcare proxy out. If we could talk about that briefly, the importance of the healthcare proxy in the minutes that we have left.
Yeah, that's again a very important document. Back in 1992, Massachusetts passed the Healthcare Proxy Act, where you can name an individual and preferably an alternate to make medical decisions for you if your physician determines you to be incapacitated. So again, it takes your doctor to be able to trigger the healthcare proxy. But when the doctor triggers that, they can then look to your first choice under that document, the agent that you're appointing to make healthcare decisions for you, and that person could assess what's going on medically and get all the information that they need to get and to try to come up with a decision that you would make if you were competent and alert enough to be able to make your own medical decision. And it also protects the medical people because they can share information with the healthcare agent and then letting them know what's going on with the patient, what their recommendations that maybe should be done. And the agent needs to assess this information, then try to determine, hey, what would the patient, the principal, the person who signed the healthcare proxy, what would they want to do if they were competent and alert enough now to make their own medical decision?
Well,
So
thank
again,
you.
a very, very important document. Should be part of everybody's base estate planning documents.
Well, as you can see, there's a myriad of information to be shared with all of you that are watching this program, and hopefully the many more that will be watching the program as we go forward. My dear friend and colleague, Attorney Paul Tierney, and myself will be bringing forth shows that will have a lot of meaning, a lot of impact that will affect all of you going forward, as it does ourselves. And we hope that you'll tune in often. And with that, thank you for tuning in to our first show, your long-range plan. Thank you.